To the honourable member for Timmins, James Bay.
Thank you, Mr. Speaker. I rise today on a question of privilege, an issue that I think goes beyond merely the procedural wranglings that often happen in the House, but actually speak to issues that are confronting us as a nation and goes very much to the heart of the question of what are our obligations as parliamentarians and what do we need to do as a nation to address historic wrongs. As I walked to Parliament Hill this morning, Mr. Speaker, I noticed that the national flag continues to fly at half-mast. That's an extraordinary move, that the flags across this nation are at half-mast. And they're there, of course, to pay respect to the 215 children at the former Catholic residential school in Kamloops, whose bodies have been found. And since then, we've now know the children found in Manitoba, and we know that we will find many, many other children who never got to go home. And Mr. Speaker, I'm sure you took the time to stop at the Eternal Flame to see that extraordinary outpouring of sadness and respect for the children who've been taken. It shows that Canadians from all walks of life are not only shocked and saddened by what has happened to Indigenous children, but are looking to these institutions to correct it. Because the deaths of these children was not accidental. These children died through deliberate policies that were made in the chamber of the House of Commons. The taking of Indigenous children from their families, Mr. Speaker, was done to destroy Indigenous identity in Canada, and it meets one of the tests, the international tests of genocide, of the destruction of a people, is the taking of the children. And I say this in leading up to my point of privilege, because if you do, and I encourage my colleagues and citizens to go see the memorial that's at the Flame right now, because for the Indigenous people of this country, these are not historic wrongs, as the government always uses that term. It is a present-day attack through the broken social welfare system of the taking of children that has continued without pause since Confederation, and we have more children in the broken child welfare system today than ever were taken in the residential schools. So the background to this, of course, is that in response to the revelations in Kamloops and the shock on the part of Canadians and the demand for action, that we brought to this House on June 7th a motion that was voted unanimously, that given the discovery of the grave of 215 children at Kamloops Indian Residential School has led to an outpouring of grief and anger across Canada, that the vast majority of the Truth and Reconciliation Commission calls to action have remained uncompleted despite the clear path to justice and reconciliation that the Commission provides, that survivors, families, and nations are demanding concrete action to advance reconciliation as opposed to just more words and symbolic gestures, that this House calls on the government to A, cease its belligerent and litigious approach to justice for Indigenous children by immediately dropping its appeal before the federal court in file numbers T-1621-19 on compensation and T-1559-20, the Jordan's Principle for Non-Status First Nation Children recognized by their nations, and to recognize the government's legal obligation to fully comply with the Canadian Human Rights Tribunal orders in this regard. B, that the government agreed to sit down with the St. Anne's Residential School Survivors Association, Petebec-Kiwewin Association, to find a just solution to the fact that survivors' access to justice has been denied as a consequence of the actions of government lawyers in suppressing evidence at the independent assessment process. C, accelerate the implementation of the Truth and Reconciliation Commission's calls to action, including by providing immediate further funding for further investigation into the deaths and disappearances of children at residential schools in compliance with calls to action 71 to 76. D, provide survivors, their families, and their communities with the appropriate resources to assist with the emotional, physical, spiritual, mental, and cultural trauma resulting from the residential schools. And E, within 10 days, table a progress report on the actions taken in compliance with paragraphs A through D of the present motion, and that this report be deemed to have been referred to the Standing Committee on Indigenous and Northern Affairs for consideration upon tabling. I want to just stress, Mr. Speaker, the call that within 10 days to table a progress report on the actions taken in compliance with paragraphs A to D in the motion that was voted on unanimously in the House of Commons, and that that report be referred to the Standing Committee on Indigenous and Northern Affairs. Well, late last night, the Liberal government presented a report at the 11th hour, but this report in no way addresses the seriousness and specificity of what was laid out in the motion. In fact, it looks like some staffer did a cut and paste job and looked some stuff up on Google and has had the temerity to present this to Parliament. I mean, what we see are Liberal electoral claims and claims from the previous budget announcements, but they in no way meet the test of what was laid out in a very serious motion about reconciliation and justice, particularly the call to end the federal court case in files T162119, T155920, and to recognize that the government's legal obligation to fully comply with the Canadian Human Rights Tribunal rulings. So that report did not respect the right of members of this House to receive the documents and the information that they can see whether or not the government has respected the will of Parliament. But, Mr. Speaker, we know that within a mere days after Parliament instructed this Prime Minister to end his belligerent and toxic legal war against Indigenous children, the Prime Minister opted instead to instruct the Minister for Indigenous Services and the Attorney General to return to federal court to try and quash the 2 federal cases specifically referenced in this motion. And once again, Mr. Speaker, if you look at the memorials to the dead children that have risen across this country, wherever you look, they will show you pictures and stories of the children still being taken today. The Human Rights Tribunal found in 2016 that this government was guilty of systemic discrimination through, quote, willful and reckless policies that they knew was harmful to the children. And Parliament called on this government to end those court cases and negotiate a just solution. And this motion is not something that could be considered unfair by government or not giving them enough time, because we know that the Assembly of First Nations has an offer on the table for the government to get out of court and to settle. The government was instructed to do that. This motion was timely, and the issue of the 10 days was important because we knew that they were getting set to return to federal court. And so instead, they've opted to hold a House in contempt. And I would say, Mr. Speaker, if you listen to the explanations of the government about why they ignored Parliament, the Indigenous Service Minister said, because we know that the Prime Minister and the Indigenous Service Minister, all the key people on this file didn't even bother to show up to vote. And they said they didn't vote because they didn't want to show contempt for the courts. But they were more than willing to show contempt for the Indigenous people of this country. And they were more than willing to show contempt for Parliament. Mr. Speaker, if we have it as a fundamental principle that it's okay for Cabinet to absolve themselves of the obligation to respect the will of Parliament and to show contempt for Parliament, we are, I think, in very dangerous terrain. And I would also say, Mr. Speaker, that we are at a historical moment in this country. And this is why I bring this to you with such urgency. I brought motions of privilege in the past about government doing this or not doing that, but we are talking about the policies that led to the widespread death and damage to generations of Indigenous children, and that the government says these are historic harms have been proven not to be true. It is ongoing. And what is incredibly cynical, Mr. Speaker, is that in ignoring the order of Parliament, we see what's actually in the legal case by the federal government, because this Minister of Indigenous Services has misled this House time and time and time again. He claims that, well, we're just trying to clarify jurisdictional questions. No, they're not. They're trying to quash the ruling. He claims that, quote, the tribunal failed to give due consideration to Canada's right to procedural fairness through this process, and that when Canada raised concerns about the lack of procedural process of fairness, the tribunal stated that any procedural unfairness to Canada is outweighed by the prejudice borne by the victims of discrimination. And yet, the minister took that statement that clearly says that the harms that have been done to children far outweigh the procedural fairness to the government, and are using that to attack the tribunal at federal court. And I raise this, Mr. Speaker, because in the motion it speaks about St. Anne's residential school survivors, where the federal government took the exact opposite position and said that St. Anne's survivors were not entitled to the basic principle of procedural fairness. But when it comes to denying basic services and rights to Indigenous people, the government will flip its argument. So, Mr. Speaker, I'm getting to the point of the issue of contempt. The House of Commons procedure and practices says that while contempt can be hard to define, quote, the United Kingdom Joint Committee on Parliamentary Privilege attempted to provide a list of some types of contempt in its 1990 report, including without reasonable excuse refusing to answer a question or provide information or produce papers formally required by the House or a committee, and without reasonable excuse disobeying a lawful order of the House or committee. And contempt is not limited to specific circumstances, but is intentionally meant to be wide-ranging and to provide the ability of the House to determine when that bar has been reached. In this case, the government has been ordered by Parliament to end its toxic legal war that has cost over $10 million in legal fees, resulted in 19 non-compliance orders, have seen obstruction after obstruction after obstruction. They've been ordered to end this legal war and to sit down and negotiate when we know that there's a negotiating table waiting for them. And they have misled the House continually. Just the other day, the Minister for Indigenous Services claimed that just because he hasn't put a 6-year-old on the witness stand means that technically he's not fighting these children in court, when in fact their legal argument rests on the dubious case that since these children were found to have suffered systemic discrimination, that the tribunal refers to as willful and reckless discrimination, that since they suffered mass discrimination, none of them are individually eligible for compensation. How can that be? And the government has also said that there has to be a test. So that means that, unless these 6 and 12 and 15-year-olds are brought before a government body to be tested for how much suffering they endured, they will fight the tribunal. Mr. Speaker, the reason that the government was hit with the $40,000 of compensation per child has to be understood very clearly. It's because when the ruling came down in 2016 and the Prime Minister said he would not contest the order, he had an opportunity then to work with Cindy Blackstock, the First Nations Family, Child and Caring Society, and the Assembly of First Nations and the other players to sit down and negotiate a way to end these harms. Instead, they didn't. They fought, they obstructed, they continually ran on the principle that they were not accountable for the lives of children. And in the end, the tribunal was so frustrated they gave the maximum penalty of $40,000 per person, per child in this case, because they said it was the worst case of indifference that the Human Rights Tribunal has ever seen, which happened under this government. And the fact that this government is continuing with these actions are contrary to the will of the House and is therefore an affront to the House. And it is now up to the House to determine the action that is needed. And I say this again, Mr. Speaker, because we are at a historic crossroads. People are looking, and Indigenous people are looking whether we take this seriously, because Canada's argument all along has been that no evidence of children having been harmed through systemic and willful and reckless discrimination. They say there's no evidence that children have been harmed, when we know that we lose a child every Monday, Wednesday, and Saturday in those broken systems. 3 children a week, and no one over there seems to even notice. And now they're saying they've clarified, they've changed after all these losing time and time and time again. I mean, my God, they've had more failures than the Ford Pinto when it comes to fighting Indigenous kids in court. They've lost every single decision. Mr. Speaker, this is not the first time the government has failed to comply with a motion on this exact issue. On December 13th, 2019, the member for New Westminster Burnaby raised a question of privilege, alleging that the government had not complied with a motion that I had presented and was adopted unanimously in the House, calling on the government to abide by a decision made by the Canadian Human Rights Tribunal on the compensation of residential school survivors. And in the Speaker's ruling of January 27, 2020, which was the Speaker's very first ruling, he said, well, for a motion to constitute an order of the House, it would have to pertain to those matters where the House, acting alone, possesses the power to compel an action. Now, this is true, for example, he says, when the House sends for persons, papers or records, or when it regulates its own internal proceedings. Only in such circumstances will the Chair determine whether disregard for the order in question constitutes a prima facie case in contempt. We were unsuccessful at that time, but today's case is substantially different, because the motion put forward was a substantive, debatable motion placed on the order paper, and that motion was subject to a recorded division. Therefore, it carries more weight because of than the unanimous consent that was expressed in 2019. In this case, it was clearly the will of the House that a document be produced and referred to the appropriate standing committee, and that document was specific to the issues related to the court cases and whether or not the government was going to respect the will of the House. And earlier this week, I will remind you, Mr. Speaker, that the government was found to having breached privilege on some issues that are very pertinent to this. And it was argued by the official opposition House leader this week in May 2019 report on the power to send for papers. The United Kingdom House of Commons Procedure Committee concluded at paragraph 16, the power of the House of Commons to require the production of papers is in theory absolute. It is binding on ministers, and its exercise has consistently been complied by the government, has been consistently been complied with by the government. The Speaker was very wise on that ruling and that matter when he stated, while they're not being challenged, it is still worth recalling that at the heart of the parliamentary system and firmly anchored in our Constitution, there are rights and privileges that are indispensable to the performance of the members' duties. And for this, we need to receive the documents that treat matters as urgent as the lives of Indigenous children, and the issue of the finding of systemic discrimination to be treated with the seriousness and respect. Because, Mr. Speaker, I'm going to conclude, but I want to mention 2 children, Jolyn Winter and Chantal Fox, age 12 years old, who died in Wapakika Reserve, and I keep their photos with me in my office. People of Wapakika begged this government during the Human Rights Tribunal to get help to children in Wapakika, and the government claimed that it was their right to decide whether or not these children got services. And those 2 12-year-old children died, and they were loved, and they are mourned. And they're mourned like so many other children have died. And this government was found guilty in the Human Rights Tribunal in one of the many, many non-compliance orders of being complicit in their deaths for their attitude that the government of Canada is not accountable to the Human Rights Tribunal. And Parliament, in paying tribute to the deaths of those children and the other children who suffered, has called on this government to change track, and they're refusing. The vote, Mr. Speaker, was a vote for reconciliation. It was a vote for recognizing the role that this institution played in policies that deliberately attempted to destroy children and destroy the Indigenous people. And it was a vote that told the government that these issues are not historic wrongs, but ongoing policies that have caused and continue to do serious damage to the Indigenous families of this nation. From the residential schools, to the 60s scoop, to the millennial scoop, to the children being taken today, there is an unbroken line of intent and damage and systemic abuse. Mr. Speaker, I urge you, we are standing at a historic moment of reckoning. And I'd like to quote and finish on this. The member for Nunavut, who just spoke this week. She said, "This place was built on the oppression of Indigenous peoples. Our history is stained with blood, children, youth, adults, and elders' blood. It is time to face the scale of justice. On one side, we have a mountain of suffering, and whenever the government gives us a grain of sand of support, they seem to think that the trauma of our past has been rectified and that somehow they deserve a pat on the back. But it will take more than a mountain of support to even begin the healing process, because as long as these halls echo with empty promises instead of real action," she says, "I will not belong here." Mr. Speaker, I urge you, in your role representing the Parliament and all our members, to hold this government to account for their contempt, their breach of privilege, and their ongoing attack on the Indigenous families and children of this nation. Thank you, merci, miigwech.
I'll take under advisement the words of the honourable member for Timmins James Bay and take this into consideration in the time ahead and get back to the House in due course.